IP for Dummies.
When it comes to intellectual property, there are many things that cross your mind, like patent, brand, trademark, copyright, trade secret, geographical indication, but not everyone has clear knowledge about all of them, so we make this series of every misconception in IP. For the very first episode, we gonna talk about copyright, the one you may have heard of 1,000 times, but not completely understands about it. So in general, copyright means right of organizations, individuals and the work created or owned by them. From this definition, we have the first misunderstanding, that is, the author is also the owner of the work they create. No, author and owner are completely different. They hold totally different rights. So to distinguish these two, we consider the definition and the right of each. First, the author is the creator of a work, such as the author of a book, the photographer who took a picture, the artist who painted a painting, a musician who recorded a song, and so on. He has the moral rights including give titles to the works, attach his real name or pseudonym to the works, publish the works, and protect the integrity of the works. On the other hand, owner is the person or entity who uses time, make a financial investment in or use his material and technical facilities to create works. He has the economic rights or exploitation rights, which mean the rights to reproduce the works, make derivative works, display the works, communicate and distribute the works to the public. For example, a magazine hired a photographer to take picture for them. Then the photographer here is the author, because he is the one created the picture, and the magazine is the owner, because they paid the photographer to create it, or they made an investment for creation of the work. Therefore, they can publish, distribute and make profit from those pictures. In fact, there are the cases that one can be author as well as owner. Back to the example, if the photographer uses his own money to pay the costs, set up his own camera, takes pictures and publish that, he will be both author and owner. 2. Your amazing, awesome, incredible idea can be protected under copyright law. Unfortunately, copyright law protects only the form of expression of ideas, such as the choice and arrangement of words, musical notes, colors, shapes, not the ideas themselves. Because one of the conditions for copyright protection is the fixation characteristic of the work, which means it must be created and expressed in a specific form. The idea is the first critical step, but without some identifiable embodiment of the idea there can be no intellectual property protection obtained, and no exclusive rights will flow unto you. This does not mean that you should give up when you only have an idea, but it does mean that you will need to proceed to flesh out your idea to the point where it is concrete enough to be more than a mere idea. So the story here is that ideas alone is an exclusion which cannot be protected. 3. You have to register to copyright your work. Artists and writers are often surprised to learn that copyright is automatic. This principle was first laid down in the Berne Convention 1886, that is, copyright protection exists right from the moment the work is created, and nothing needs to be done to claim copyright protection. But formal registration brings some significant benefits. It establishes a public record of the copyright claim, reducing the risk and damages of infringement, especially when right transfer or exploitation is made. 4. Once your work is copyrighted, it will be protected everywhere and forever. There's still some limitations in copyright law. 2 of these are the limit of place and time. Sadly, there is no international copyright system. The laws and procedures for copyright protection are not the same worldwide. Copyright laws of one country are applied only within that country, so the work is protected only inside the country's border, not in other countries. In order to have global protection for the product, firm has to register to every country. But the good news is, in fact, there are some international treaties that help coordinate and standardize copyright protection among all the countries that are signatories to the treaties. The 2 broadest treaties are the Berne Convention and the World Intellectual Property Organization Copyright Treaty. These international treaties assure that your work, copyrighted in one member country, also receives copyright protection in other member countries. About limit of time. Although Berne sets a minimum duration of a copyright in a literary work equal to the life of the author plus 50 years, the duration of copyright may vary from country to country according to the type of work. For example, in USA, since 1978, with published or unpublished works the length of protection is life plus 70 years. With anonymous works, pseudonymous works, or works made for hire, this length is calculated by 95 years from publication or 120 years from creation, whichever is shorter. While in Vietnam, 3 out of 4 moral rights last forever, but economic rights and the right to publish are lasted for 75 years after the death of the author. These differences in national laws imply the fact that in some cases a specific work can still be in copyright in some countries but no longer in others, and therefore belongs to public domain. 5. Using copyrighted work without permission of the author-owner is copyright infringement. This is true, but not always true. There is a doctrine of fair use determining when you can freely use someone's copyrighted work without permission. This includes personal use or non-commercial purposes such as parody, criticism, comment, news, and education. We have here some guideline for fair use. For non-profit purposes, check who owns it. Give credit to the creator. Use responsibly. Buy it if necessary. In conclusion, remember the general rule: you don't always need permission to use the work, but always try to get permission, because fair use is very difficult to prove. The only way you can really prove it is in court. That's the end of video. Thanks for watching. Goodbye.